Off. All right. Hello, everybody, and welcome to Law at the Library, a partnership between the Chicago Bar Association, the Evanston Public Library, and the Chicago Public Library. My name is Lorena Neal. My pronouns are she, her, and I'm the legal literacy librarian at the Evanston Public Library. We're delighted to have everyone here tonight for this presentation on landlord-tenant law. I'm going to tell you a little bit about the format for this evening, and then we'll get started. I'm going to introduce our speaker, who will then give the presentation, followed by a question and answer period. If you have any questions for our speaker, please type them into the Q&A window, which you will find near the bottom of your Zoom screen. You can also use the chat feature to ask your questions if you prefer. I'll collect all the questions as they come up and give our presenter the opportunity to answer them at the end of the presentation. So feel free to add your questions whenever you think of them. And if you have any technical issues or questions, feel free to direct those to me in the chat as well. Our next Law at the Library session will be on March 18th, and the topic will be legal and business issues for creatives. I'll put the link to register in the chat in just a moment here. In the meantime, you can always see videos of previous presentations of Law at the Library on the Evanston Public Library's YouTube page. I'll post a link in our chat for the playlist for that as well. We also have a list of general free and low-cost legal resources on EPL's website, which I will link in the chat. And finally, if you are interested in election guides for the upcoming primary elections on March 17th, the Chicago Board of Election Commissioners has put together a helpful list on how to research the candidates for all of the positions on your ballot, which I will again link in the chat for you. One of the guides is from the Chicago Bar Association, and it's their smart guide to the judges up to elections, so we encourage you to check that out. Our speaker tonight is Kimber Russell. Kimber is an attorney with extensive experience in eviction court and has been a tenants advocate throughout the legal career. She is now the first litigating attorney at Carpels, which has been solely a legal aid hotline since its inception. We're thrilled to have you tonight, Kimber, and I will turn things over to you now.
All right, so let me go ahead and share my screen so we can all be on the same page here, and let's get into it. All right, can everybody see that? You got that? All right, great. Well, thank you so much for that kind and warm welcome. My name is Kimber Russell. I am an attorney at Carpels. For the last 30 years, we've been a legal aid hotline, and we also, at the end of my presentation, I'll give you some more information about the various services that we provide in Cook County, Illinois, of which Evanston is a part. Tonight, we're going to be talking pretty much just about renters' rights, and I'm also open at the end to answer if we have some landlords out there who have some questions. I'm happy to answer those questions as well. But tonight, we're going to talk about renters' rights. And one of the things we're going to get into is ordinances. Super fun and sexy topic, but it's something that's very important and it impacts all of us, especially Evanston has their own resident landlord tenant ordinance. There's the Cook County resident landlord tenant ordinance. Chicago's got one. There's a bunch of them. Even just in the state of Illinois, we got several. So let's talk about what does an ordinance actually do? It's a fancy word, but what does it actually do? Well, it protects us. First things first, governs security deposits. These are the rules that are set forth that allows us to get back our security deposits in a timely manner and lays out a framework for doing that. And it provides us with the right to make sure the landlords aren't just popping in whenever they want to. It gives us the right to set some standards for when they can and can't come in and when they're able to have access to the property. Limits the reasons that a person can be evicted. It's not just I feel some type of way about you and I don't like the cut of your jib. There are specific reasons why you can evict, reasons why you can't. Habitability is a big one. Landlords have to maintain the habitability of each apartment. That's just a fancy way of saying the conditions they must allow you to have a good living space that is clean, sanitary, and everything is working. And where we see a lot of issues in eviction court and even just regular housing court is a breach of the warranty of habitability, which is a fancy way of saying landlords are supposed to provide certain things. And if they fall short of that, you may have legal recourse. And again, we're talking about legal recourse. What is one of the reasons why a landlord may seek to evict you when you're paid up on the rent? Well, retaliation. An ordinance like the Evanston Resident Landlord Tenant Ordinance, Cook County, Chicago's, prohibits, meaning it makes it illegal to retaliate against a tenant for asking for things that you're able to get under the law. Case in point, I've got issues with the building. There's no heat. So I called 311. I reported it. And 2 days later, I get an eviction notice. That's retaliation. There's legal recourse for that. And lockouts. This happens a lot when we have a pro se landlord. That's a fancy kind of Latin way of saying that you represent yourself. Sometimes you may have a family home that you've decided to rent out. You decided you could do it on your own. You didn't come to a presentation like this. You didn't know there was an ordinance or that there were laws in place that govern the relationship between landlords and tenants. And you decided, oh, they didn't pay their rent. I'm locking them out. That is something that you can't do. And that is definitely something that any of the legal aid organizations that we've discussed tonight or that we will discuss tonight, especially mine, Carpels, can assist you with further if you have those kinds of issues. And finally, ordinances can provide you with money damages for violations of the ordinance. Sometimes those violations are on the tenant side, but sometimes they're on the landlord side. What type of money damages could we potentially get? Well, for example, when you enter into a lease agreement and the landlord accepts a security deposit from you, these ordinances require that that money, which is your money, be kept in a separate interest-bearing account that is not commingled, which is a fancy way of saying mixed with all the landlord's private money. There needs to be a separate tenant's account. The money must be held there. You must be given credit for the interest every year that the money is held there. And that money does not just immediately inure to the benefit of the landlord in the event that the tenant is behind on rent. That cannot be used for rent unless or until there's an agreement to that effect or there are other rules in play there. But for example, if your landlord doesn't return your security deposit to you in a timely fashion under the rules of these ordinances, you can potentially sue them and even get money damages, twice the amount of your security deposit and attorney's fees, which means that there are attorneys out here who will take your case because they know that if they succeed, they'll be able to get paid. So these are just some of the things that ordinances do. They do a lot more than that, but that's just a little bit of what they do. But let's talk tonight specifically about Chicago and Cook County. Now, again, Evanston has its own special ordinance that has certain different rules, but just so that we kind of hit as many kind of areas as we can, we're going to talk about the Cook County and the Chicago resident landlord tenant ordinances. These pretty much all the ordinances have similar rules. Chicago and Cook County have some additional kind of carve outs. For example, this ordinance, these housing ordinances only apply if the building has six or fewer units, or sorry, it applies if there are six. It doesn't apply if there are six or fewer units and it's owner occupied. So let's say, for example, your landlord lives on the top floor. This wouldn't apply. There's 5 units in the building. This wouldn't apply. Okay. So that doesn't mean that you have no rights. It's still the regular Illinois law on forcible detainer actions would apply, but it's a little less protective than the Chicago and the Cook County ordinances are. But for the most part, there aren't a ton of cases like this out there. It's pretty rare. So let's talk about the things that these two ordinances do and do not cover. Let's first talk about some things that they don't cover. Hotels, medical facilities, dorm rooms in Evanston. We've got a college right there. Religious facilities. These are not covered by landlord tenant ordinances unless something shifts and we're in a sort of a quasi-tenant situation. You're not going to get evicted from a hospital. You could potentially get evicted from a hotel eventually if you overstay. Once you've been there more than 30 days, you've kind of got a quasi tenancy and you do have to go through an eviction process, but you don't have the benefit of the ordinances because they simply are a different type of housing that we have carved out. Co-ops, condominiums. Now, if you're a renter renting someone's condominium or co-op, you have all the benefits of these ordinances. You still have the landlord-tenant benefits. If you own a condominium, you're not going to get the same kind of benefit because you're a homeowner and there's different rules that apply to you, and you're going to be largely governed by your homeowners association rules and regulations or your condo board rules and regulations. Those are the things that are going to govern. Again, owner-occupied buildings with fewer than 6 units aren't going to be covered by this. It does cover subsidized and HUD housing. So if you live in a project-based housing that is rent stabilized or otherwise maybe income-based, something like that, you still have a landlord-tenant relationship with the housing authority, the Chicago Housing Authority, the Cook County Housing Authority. And this also covers folks who get vouchers as well. You still have the benefit of these ordinances. And anything that has more than 7 units obviously is going to be covered by the landlord-tenant ordinance. And again, if it's 6 or fewer, but the landlord doesn't live there, you're still covered by the ordinance. So there we go. The landlord doesn't live there, and it's six or more units. Okay. Now, conditions are the big things that a lot of folks are going to have trouble with. So let's talk about what can you do when you have issues with your conditions in your unit. Because one of the things that every landlord has to provide is a safe and habitable place to stay. It's called the warranty of habitability. It's just a fancy way of saying this place has to be fit and decent to live in, right? So this comes down to what we call the landlord's duty to maintain. And that's just a fancy way of saying they've got to keep it up to snuff. They got to make sure that you have heat, electric, running water, that the grounds are kept safe, that they're shoveling snow, that the stairs aren't icy, stuff like that. There's a legal duty to keep the rental unit in a habitable condition. And so it's not just health and safety, it's providing heat, hot water, plumbing and electrical systems to make sure that you have everything that you need to have a good quality of a tenancy. So if you don't have hot water, they're failing their duty to maintain. If they've shut off your utilities in some way, there's a failure there. There's a breach. And again, we call that the breach of the warranty of habitability. It just rolls off the tongue. So let's talk about what constitutes regular maintenance and when does it come into non-compliance. Now, we got a lot of fancy legal words here. Compliance means the landlord has to do the basic things in every lease. When you get a lease agreement, it's going to outline what the landlord is responsible for and what you're responsible for. Sometimes you may be responsible for subsidizing the landlord's water bill, sewage, trash pickup. They can do that. They can include as a separate charge paying for utilities. But what they can't do is interfere with you getting those utilities because you're not paying. So for example, but let's talk about what happens when there are just like, maybe you've got a leaky toilet. Leaky toilet happens a lot, right? So this is something that is not necessarily an emergency, but it is something that's going to potentially negatively impact your quality of your tenancy, your ability to quietly enjoy your unit. You can do something called self-help. Now, that doesn't mean take out your wrench and start working on the toilet, but it does mean you can send something called a 14-day letter. And what that means is you actually write a letter. It doesn't have to be handwritten. It can be typed up. It can be an email, but you need to send the document to the landlord, the property manager, whoever it is that is normally the person who is responsible for maintenance, and tell them, hey, landlord, I got this leaky toilet. You've got 14 days to fix it, or I'm going to take care of this myself. Now, what that means is you give them 14 days. If they fix it, fantastic. If they don't, at that point, then you can go get a plumber. You can have the plumber fix it. And then you can tell the landlord in the next month, here's the invoice. Here's what I paid. I'm deducting this amount from the next month's rent. This is crucial. This is where a lot of tenants get a little bit twisted. You can only withhold a portion of the rent. You can never withhold the full amount of the rent, even if you're having serious issues. There's other remedies you can go to, but if you're looking, and that's when we're going to talk about, if you have serious problems, you can break the lease and move, like Beyonce said. If it's a bugaboo, break your lease and move. But if you've got a leaky toilet or a leaky sink, you've got some mold in the shower, or maybe you have some issues with heat in one of your rooms. If it's something that you can actually take care of, and it's not going to be more than 50% of your rent, then you can take advantage of these self-help options. But please, please, please do not ever just stop paying rent because your sink is leaking. And do not withhold rent without informing the landlord. You always got to send your 14-day letter, and you got to give them the full 14 days. And I know it can be somewhat unnerving to have to endure this issue. That's why these are regular maintenance things. If the toilet literally will not work, that's more urgent. That's going to be something that needs to be taken care of immediately. And we'll talk about what you can do when it's more serious. Because if it's so serious that it makes the unit uninhabitable, at that point, you got the right to break your lease. But for most things, if you have the ability to do self-help, if you go through the process, write the letter, send it to them. And again, we like to send it both regular mail and certified, because a lot of landlords will try to refuse to sign off on a certified letter. So that's why we like to send both. That way you always have proof. Because if they do file a case against you because they disagree with you withholding rent, they still can do that. And you need to be able to prove in court that you took all the right steps, you complied with the ordinance the proper way, and that you made sure that you had all of your evidence there ready to go. So just follow the rules there. Okay. So now, material noncompliance. I was talking about, like, leaky sinks and toilets. Material noncompliance is if something seriously goes wrong. Like, there's absolutely no water in my unit and it's been 3 days. You can't stay there. You can't live there. You need water to basically function. Or if they were doing something and they knocked out all the power and there's no power in the building for days and days. Material noncompliance is just a fancy way of saying this place is no longer what I signed up for. I've signed up for a 3-bedroom room, and now I don't have a 3-bedroom apartment anymore. The ceiling fully collapsed in one of these rooms. I no longer have access to that room. There's black mold everywhere. There was flooding and sewage backed up. We can't stay here anymore, right? So or let's just say they shut off the water. And I've definitely spoken to tenants over the years who are like, I haven't had water for a week. Well, that's crazy. That would be a material breach. So again, we talked about notice. And it's always important when you're starting on this enterprise of trying to do self-help, you gotta make sure you tell the landlord. And it's not enough to tell the maintenance man. You have to go as high up as you can. If it's the landlord, whoever's named in your lease, or if it's the property manager, it's not enough to send a text or just verbally ask. You have to make a paper trail every single time, okay? And I know a lot of folks get a little confused, because if your building is managed by a property manager, they aren't necessarily the landlord, right? They just have been contracted to run or manage the property. They don't necessarily know the rules. They don't necessarily know the law. They can sometimes make promises that they don't have the ability to keep, or they may tell you things that are incorrect. So my motto is trust but verify. every time. If there's a process in place, and many buildings do have a process where you have to put in a ticket for maintenance in order to get the work to be done. So if that is outlined in your lease, make sure you follow the process, okay? Make sure you read your lease. I know they're very dense and boring, but that's why our legal aid organization is here for. We can read the lease for you and explain it to you, but don't sign anything you don't understand. And make sure you do understand the process for getting repairs done, okay? But every step of the way, make sure that you are proving that you did what needed to be done. You got a copy of a letter. Don't just type a letter and mail it. You want to make sure you've got digital copies, that you're scanning every document, and you can do it with an iPhone. That you could do it with a cell phone now. There's so many ways that you can capture the evidence that you need, but make sure you've always got a paper trail. And I like to hit them from every angle. I will send them a letter, snail mail. I'll send it certified. I'll email it to them. I'll attach it to a text message. I'll send it by carrier pigeon. I want to make sure that I have every angle covered so they can't say, we didn't know. And then she just stopped paying the rent. No such thing as too much notice. No such thing as too much notice. The one thing you're never going to hear a judge say is, well, there's simply too much evidence here. We can't make a determination. No, no such thing as too much notice. So again, urgent issues. We live in a very cold area. Okay, now today we had lovely weather, but we've had polar vortex, we've had blizzards, we had a fire alert today. So when there are urgent issues, there are further steps you can take. Now, essential services is typically what we're talking about when we're talking about like this material non-compliance. Landlords may not. And this is not just like vibes, guys. The landlord must provide heat. In Chicago, we actually have a cooling ordinance now where if there are common areas, or if there's a certain number of units in the building, the landlords have to provide cooling for people, because obviously we have a lot of issues where we have folks who have suffered greatly because they don't have access to just cooling in the summertime. And we had some 100-some-degree days this past summer that were pretty dangerous. Same thing for the heat. It's simply just not legal to turn off someone's heat for any reason, or to expect people to survive in sub-zero temperatures for weeks and weeks and weeks. And I've talked to too many tenants who the heat is out, they're afraid to do anything about it, so they just open up their oven, pull the oven door down, or put a pot of boiling water on the stove. That's just not sustainable, and it's not a good quality of life for you. You don't have to live like that. If you are missing heat, gas, electricity, hot water, anything that the landlord is supposed to provide, then you can give the written notice to the landlord saying, this is a material non-compliance with the lease. You got to provide the basic essentials. And if you can't do that, I'm out, right? You can break your lease at that point. There's a way to do it. We're going to talk about it. But let's talk about what are the requirements for heat, first of all. The Cook County ordinance requires that from September 15th to June 1st, that it is at least 68 degrees in your unit between 8:30 a.m. and 10:30 p.m. And it can go down to 66 degrees from 10:30 p.m. to 8:30 a.m. If the temperature is lower than that, we got a violation. Okay, we got a violation, and that would constitute material non-compliance. Now in Chicago, it's even worse for the landlords because they could be charged $1,000 per day for each violation where a unit does not have heat. And it doesn't matter why the heat's out. If the furnace just conks out, they better figure something out. They definitely better figure something out, or else they could be paying for you to stay in a hotel for every day that there's no heat, no water, no gas, no electricity in that unit. It matters not the reason. That you don't get a free pass. Like, well, the furnace is out. What was I supposed to do? Send them to a hotel, or else people have the ability to break their lease. You can't be expected to survive in a situation where you don't have your essential services. So here's what we do in the event. Let's say the heat is out and it's polar vortex, right? So you're going to send the notice again every kind of way you can, text, email, phone, send it every kind of way, but make sure that you're keeping track and always keep all of these papers together in a place where you can easily find them so that you can bring them up later on. But what you would be doing is saying, hey, landlord, I got no heat. The heat needs to be restored within 24 hours. You can then, you can potentially withhold a portion of the rent. Typically, the way that we would do that would be there's no heat in my house. I'm going to go stay in a hotel. For each day that I stay in a hotel, I'm going to withhold that amount of money for the next month's rent. That's where we're talking about substitute housing, right? And again, if after 3 days, 72 hours, if they haven't returned the water, the heat, any of the essential services, at that point, you can tell the landlord, hey, I told you we didn't have heat. It's been 3 days. It's polar vortex. It's still no heat. I'm outie. I'm outie 5,000. Bye-bye. And they're not going to be able to try and pull any early termination fees on you, because a lot of landlords, if you look in your lease, there'll be these things called early termination provisions, which means if you try to break your lease, they'll be like, well, we want the other 6 months of rent that you owe us, or we want a $2,500 penalty. They're not going to be able to do that if they were in material noncompliance with essential health and safety. So I'm sure everybody has questions about evictions. Now, a little bit about me. Why do I do this? Why am I such a staunch housing advocate? Because I've been evicted 3 times in my life in 3 different states with 3 different regimes. And I got so used to learning all the information about the ordinances and the New York stabilized housing rules and how different it was when I grew up in Ohio, right? It was so impactful on me when I was 13 years old. That was the first time I was ever evicted. And as a kid, you can imagine it's pretty traumatic. And I kind of pledged to myself at that time, I want to make sure that I can help other people to not have to do that. And that's how I ended up becoming a housing attorney, to help people through this process. Because a lot of us face eviction for a lot of different reasons. Maybe it's retaliatory. Maybe it's because we fell behind on the rent. Maybe it's the pandemic. There's a lot of reasons, but we're gonna explain the process and how you can handle it. So let's talk about proper notice, okay? Because one of the main reasons why eviction cases end up taking a long time to work through the courts or just being thrown out is because you're not being given proper notice. There are several types of notices, and in Chicago we got a whole slew of them, but let's just talk about the basic kind of notices first of all. Now, in the event that you fall behind on your rent, the proper notice for you to receive is called a 5-day notice. And what that enables you to do is to pay up and cure. We always use fancy words. Why not? We're lawyers. We got to make that law degree pay. But if you receive a 5-day notice, you have 5 days from the day that you receive it. So it's not the date that the day after is when it starts. So they give it to you and then you have 5 days after that. Okay. And again, if they give it to you over a weekend, usually sometimes you'll get an extra day in there as well. So for the most part, if you get a 5-day notice, as long as you pay all the late fees and whatever other fees and costs and, all rents due and owing, then they can't file for eviction if you cure. If they accept a partial payment, they can still pursue the eviction, because in order to effectuate a cure, you have to pay the full amount that's due and owing. Now, I get a lot of questions from tenants. Well, they won't give me a payment plan, or, I'm used to paying on the 15th of the month. Some of these things, the landlord will let you get away with, but if it's not in your lease, if the lease says your rent is late on the 5th day of the month, it's late, okay? Because what's going to happen is any kind of agreements or verbal agreements or gentlemen's agreements that you may have outside the 4 corners of that lease, Those things are not coming into court later. Well, the property manager said it was okay if I paid my rent on the 15th of the month. If it's not in the lease, it doesn't matter. You can still be in breach even if somebody outside of that lease agreement tells you. So don't believe the hype. If a property manager is giving you grace, take it for what it is. But you're not going to be able to go into a court of law and say, well, the property manager said I didn't have to pay until the 8th of the month. That's not going to hold up if the lease says it's late on the 5th. But as long as you cure fully within that 5-day period, you're going to be able to maintain your tenancy and proceed till the end of your lease or until you renew your lease. Now, if there's a lease violation, the landlord has to give you a 10-day notice. What would constitute a lease violation? You're smoking in the unit, and it was a non-smoking unit. Now in Illinois, we have legal cannabis, and I know there are dispensaries in Evanston, and I know there's dispensaries in Chicago. It is not legal to smoke marijuana in any kind of federal or federal subsidized housing, period. Period. The state law does contradict the federal law, right? But any kind of subsidized, federally funded housing, you can lose your tenancy if you violate that. So if they say don't do crimes, you're probably not going to be able to cure that. The type of 10-day lease violation that you could cure would be you got a dog, you weren't supposed to have a dog. You got rid of the dog, you've cured it, right? So, but typically, if you're doing things that are unlawful or explicitly prohibited by state law ordinance, there's not much way to cure that. Like if you're criming, there's not much way to cure that. But if you're not supposed to grill on the patio and you're grilling on the patio, well, stop grilling out there and you should be fine. Now, the 30 to 120 day notice, this is more about the Chicago ordinance, and we'll get into that in a minute. But typically, there are various deadlines for how much notice you have to give somebody if you want to terminate their lease or if you're on a month-to-month lease and you don't want to renew the lease. And at a minimum, it's 30, and it can be up to 120 days, which we'll get into. In Cook County, typically, if you're on a month-to-month lease, meaning your lease expired in July, right, and you haven't renewed and you haven't gotten a new lease, anytime you've got a lease that you reach the end of the period that it covers, it automatically converts into what we call a month-to-month lease. That means it begins again on the first of every month, and then it automatically renews each month after that. Now, a lot of people say, "Oh, I don't have a lease anymore." Well, it's a little bit more nuanced than that. You don't have an enforceable lease, but you do have a tenancy, and the tenancy is going to be governed by the terms of the original lease. Those terms cannot be changed by a phone call, by a text message, by an email. They have to be renegotiated with a new lease or a new agreement, okay? And that's where we get into a lot of tricky spots with landlords can't just be calling every month and raising the rent. That's not how this works. Now, I did put down here 90-day notice for foreclosures. We're not going to be talking about that. That's if you own the property and it's been taken over by a bank. There's a whole procedure for that, but typically they give you a 90-day notice. So I wanted to go more in depth into the Chicago Fair Notice Ordinance. This is an ordinance that was enacted back in 2020, and it provides that if you have been in a landlord-tenant relationship for 6 months or less, the landlord only needs to give you 30 days notice if they want to terminate the tenancy or if they want to raise the rent. In the event that you've been there between 6 months and 3 years, the landlord needs to provide 60 days notice if they want to terminate the lease or if they want to raise the rent. And then finally, if you've been in a unit, and I've talked to a lot of people who stayed 15, 20 years in the same building, in this instance, and if it's in Chicago, and this applies to subsidized houses and also to month-to-month or verbal agreements too, even if you don't have a written lease, if you have a verbal lease agreement, this still applies. 120 days, that's 4 months notice they have to provide you if they want to terminate the tenancy or raise the rent, okay? And if they try to file an eviction before this proper notice has elapsed, that's that's grounds for a motion to dismiss. Okay, but this is just the basics for Chicago. Now in Cook County, if it's if your landlord wants to terminate the tenancy, they only have to give you 60 days notice. All right. Let's talk about how eviction court works. Now, the great thing about Cook County now is that we have a lot more protections for tenants that we didn't used to have. It used to be if you got served an eviction notice and you were given a date to go to court, you'd show up in court and that was trial. And for the most part, most people were getting evicted within 5 or 10 minutes because 95% of landlords have attorneys and only about 5% of tenants do. We're hoping to get that number up. That's why a lot of our legal aid organizations are providing more direct representation where we do full representation instead of just helping a little bit along the way. But now we have a lot more resources available to tenants. But the basic gist of it is an eviction case begins when something happens. A notice, whatever kind of notice, if it's a 5-day notice for failure to pay rent, 10-day notice for a breach of lease, or it's the landlord gave you the 60-day notice, they want to terminate because they want to sell the building and you didn't want to leave and you're still there. Well, there's another reason why they may serve the notice on you. So the notice period has to expire though. They can't give you 120 days notice and then file an eviction case 60 days later. That's not how it works. The full amount of time has to elapse. Then they file the eviction. So the eviction filing is going to include a complaint. They have to attach a copy of the notice and proof that they gave you the notice, and they can hand you the notice. The notice doesn't have to be provided by a legal process server, although sometimes folks will do it that way. But you do have to be given a copy of it. And they have to attach it to the complaint. If they don't attach it to the complaint, that's another reason why we can ask for the complaint to be dismissed. Now, once the case is filed, the landlord also has to get a summons. And that is the document that says, hey, you got to come to court. You've been served. So that summons gets placed with the sheriff. It can be served by the sheriff. Now, it's not a crime to be evicted, and getting the summons and the complaint doesn't mean you have to leave that day. It just means that you're being hauled into court and the court will have jurisdiction over you. That's why this whole process has to happen. The court cannot exert jurisdiction unless you are properly noticed and you're properly served. You can be served by a sheriff. You can be served by a special process server like Dog the Bounty Hunter, kind of like that. Or you can be served in other ways, especially if you're ducking service. There's service by publication or by alternative means. But at a minimum, these are the steps that have to be taken. Now, where there's a meritorious case, typically you'll have an agreed order. Either the folks will agree to move out by a certain date, or you'll come up maybe with a payment plan so you can pay to stay. But, if there's an eviction order entered at the end of it, if a judgment is entered, if you participate, you'll have 14 days to figure out what's going to go on before they send that order to the sheriff. Now, I want to make this very clear. Only the Cook County Sheriff can evict you. The landlord cannot come and put you out. They can't just change the locks. They can't have their property manager, some Joe Schmo from around the way. The lawyer representing the landlord can't do it. The only party that can execute an eviction order is the sheriff. And it has to be the sheriff, okay? Now, again, it's not a crime, but they are the ones that have to do it. So moving right along, let's talk about those resources I was talking about. As most of us are well aware, during the pandemic, a lot of us didn't have work, including myself. I also got laid off before we invented Zoom Court, because Zoom Court hadn't really been a thing up till then, and now it's everywhere. And that's how we do the early resolution program. If you are a Cook County tenant, this goes for everybody. Subsidized houses, people with vouchers, you're renting a condo, you're in an apartment building, you have the right to go through the early resolution program. And what this program does is when you first go to court, so let's say you got that summons, right? For whatever reason, you fell behind on the rent, you asked for repairs and they gave you this potentially in retaliation for asking for repairs. When you first go to court, you're going to have the opportunity to be transferred to an attorney like me. I was working on this program almost from its inception since 2021. I worked on the early resolution program, and the early resolution program is staffed by attorneys from the Law Center for Better Housing, my organization, Carpels, uh, the Center for Elder and Disability Law, Chicago Volunteer Legal Services, Legal Aid Chicago. All of these organizations provide attorneys on the spot. So you go to court, you finish your court date, you're given a 30-day return date, and sometimes you can be immediately transferred into another Zoom room to speak to an attorney to help you determine a way forward. One of the things we do is we help connect you with rental assistance. Currently, there's $10,000 available for folks who have not taken advantage of the rental assistance program before. So that's $10,000 for back rent and up to 2 months of future rent. And it also covers up to $700 of court costs and filing fees as well. So this is a great program, and you'll have an opportunity to either potentially negotiate a move out agreement or a pay to stay agreement, or you may be able to effectuate your one-time right to cure. In Cook County and in Chicago, tenants have a one-time right to cure, which means if you pay absolutely everything that is due and owing, all late fees, late rent, anything, and the court costs and filing fees, if you can pay that all off, they have to dismiss your case with prejudice. Okay, so this is a great program, and the program is governed by the Cook County Legal Aid for Housing and Debt. That's another hotline that my organization runs. I'm going to give you the phone number for that at the end of this presentation. This is a great resource. If you are having issues with conditions, if you are having problems with your landlord providing essential services, if you're behind on your rent and you're worried, or you just got a 5-day notice, I'm going to give you the hotline number. I want you to call it, because we can provide you with actual attorneys to give you legal advice and to hook you up with other resources as well. So one thing I really want to impress upon you, because I know that it's very tempting when you've been served with legal documents to shove them in a corner and just be like, maybe if I don't do anything about it, it'll just go away. You'll always have a better result if you go to court, for the reason that I just told you. Because if you don't go to court, you're going to miss out on the early resolution program. If you don't have an opportunity to go through the early resolution program, you might not even know about the court-based rental assistance or the other resources that are available. The ability to have an attorney either help you negotiate a move-out agreement or even potentially get full representation. All of the organizations that I mentioned that participate in the early resolution program, we all provide full representation for clients. Now, I'm the first one at Carpels. We used to just be a legal aid hotline. And as of, 2 weeks ago, I've also started providing full representation for folks who have meritorious cases or who are looking to exercise their right to cure. So don't lose hope. It always feels when you're in a situation, and I understand there's a lot of shame and just hesitance to ask for help. Please don't ever feel ashamed to ask for help. That's why we're here. We do this because we believe in the mission. We believe everybody has a right to safe, stable, sanitary housing that's heated, where you have running water, where your ceiling isn't caved in, and you're not covered with black mold or sewage backing up in the pipes. We've seen horrific conditions. You don't have to live with these conditions, and you don't have to suffer in silence. Please take advantage of all the resources, and please don't skip court, because you'll always get a better result. And I know it's scary going to court, but honestly, it's Zoom court nowadays, and it's a little bit less scary when you're just in your own home on your cell phone. Okay, so don't freak out. You can do this. So, like there are some really good reasons why you want to go to court. Number one, you'll have an opportunity to speak to an attorney. As long as you go to your first early resolution appointment, you'll be able to speak to an attorney, someone like myself. We'll explain the entire process. We'll go through all your rights. We'll go through all the resources that are available. We'll help you with your application for rental assistance. We'll make sure that we give you every possible resource that we possibly can. And if your case has merit, we may take it up for full representation so you don't even need to worry about it. But at a minimum, we can help you negotiate a settlement agreement so you don't have to go to trial. That's the goal. Um, One thing you don't want to do is just not go to court. Because if you don't go to court, the landlord can get something called a default judgment, which means they win. They just get the eviction order. And they'll send it to the sheriff within 7 days. And then at any time after that, the sheriff can just show up and put you out. Now, the sheriff doesn't do it like they used to do, where they literally would take all your stuff and throw it on the sidewalk, but they can still put you out. They'll slap a no trespassing sign up there, and you're not going to be able to get back in there. So what you don't want to do is kind of crawl into yourself and not take action. It's always better to take action. Ask for help earlier. Like when you're starting to have problems. A lot of people have been getting laid off from work. The economy ain't great right now. Don't wait until you're dug 3 months in before you ask for help for rental assistance. There's a lot of programs out there. So please call one of our legal aid hotlines. Like I said, I'm going to give you the number at the end of the presentation. Please reach out. Don't wait. It gets worse if you avoid it. And there's so many resources. And that's why we're really happy to participate in this presentation tonight, because so many people don't know that there are people out here like myself who are ready and willing and happy to help you. It's literally what I do 9 to 5 every day, is help people stay housed. That's all I do. That's all I want to do. Okay. So the other reason why it's really good to go to court is if you have an attorney helping you through this process, we can get this case sealed for you. Now, it's not a guarantee, but sealing is the remedy that takes the case out of the public record to make sure that when you go to get that next apartment, they're not going to say, ooh, I see that Kimber has these 3 evictions. I'm not renting to her. We want to make sure that you're able to successfully move forward. Everybody needs a little bit of help, and you don't want to have this hanging on your neck for the rest of time, right? So here's all of the some of the resources where you can find us. You can find us on Facebook at Carpels. New Leaf, Illinois is another program that we're affiliated with for folks who have cannabis convictions that are expungible. Please reach out to us, because that's another thing. There's so many collateral consequences having even just a cannabis conviction. Can prevent you from getting public housing, things like that. So we would love to help you with that. You can find us on LinkedIn. You can find us on Instagram at Carpels Chicago, and you can find us on the platform formerly known as Twitter at Carpels Legal or at New Leaf, Illinois. And this is what I was talking about right here. Here are some hotlines. I want you guys to take down these numbers, okay? The major one is the Cook County Legal Aid for Housing and Debt Hotline. It's available 9 a.m. to 4:30 p.m. every day of the week when the courts are open. We were closed on Monday because it was a court holiday, but and that's not just for housing. That's also for consumer debt. You got credit card issues. You're worried about your mortgage. Are you in foreclosure? You're looking for some help? Please give us a call. We also run the Illinois Armed Forces Legal Aid Network hotline for folks who are active duty or veterans of the armed forces. We can provide you with a lot of legal resources and assistance on this hotline, same hours, 9 a.m. to 4:30 p.m. And that's for all of the state of Illinois. Our housing hotline is only for Cook County, but this is for the entire state of Illinois. Anybody in the state of Illinois can call this hotline. You can also call Eviction Help Illinois. And I had mentioned New Leaf. That's the organization that assists with cannabis convictions and helping people get their records sealed or expunged. So that concludes my portion of the presentation. I'm going to go ahead and stop sharing my screen so that we can start doing the portion of the questions and answers.
Great. Thank you so much for that. That's so helpful. Will you be able to make a copy of the slides available? Or, at least the how to contact slide there?
Absolutely. I will be happy to share that with
Yeah,
everybody.
yeah.
I will email you a copy of that.
I,
Anybody
I
who
will.
wants it can have it.
Exact. Thank you so much. I will take on the emailing recipient duties, and then I will pass that on to everyone who is registered for this program. So everyone who's online, you can look forward to getting those slides. So our first question is, if a landlord charges extra for utilities like trash, electric, water, internet, is there a cap on the maximum that can be charged for one person in a studio apartment, like for non-metered utilities?
Sadly, not really. They it has to be. I mean, they can't charge you $1,000 for internet access. It does have. I mean, but there's no hard and fast rules for that. So, and we do see it's usually the water and sewer and trash pickup that tends to be the one that really causes problems for folks because those costs can be burdensome. So really, forewarned is forearmed. So that's why you always want to read your lease before you sign it, especially because sometimes there'll be an addendum and it'll be 15 pages. It'll be like, by signing this, you understand that you're going to be paying $50 a month for gas and $30 a month for water and trash pickup. Make sure that you understand. And that's why I want you to call our hotline if you're about to sign a new lease, because one of our attorneys would be more than happy to go over those provisions with you and explain what your exposure could be. But once you've signed it, you're kind of boned. So if you can't afford it, go somewhere else. Because once you've signed that, you're screwed at least for the portion of that lease until you can get out of there.
Right. Okay, thank you very much for that. Can a landlord choose not to renew your lease for any reason, or does he have to have some valid reason for not renewing?
Sad. I mean, now there are if and if you can prove it. Now this gets very hard because it's this is a difficult thing to do because if you feel like they're if it's retaliatory in nature, that's something you can challenge. Like, oh, I called 311 too many times because the electric keeps going out, or there's building code violations and they're refusing to renew my lease because it's retaliatory in nature. Um,
Mhm.
However, if they don't like the cut of your jib, they're just like, you know what, I want to sell the building. Like there's a lot of reasons why they may choose to not renew. They want to sell the building. They want to get everybody out so they can gut the place and then jack up the rents. You're not entitled to your lease being renewed. There are some, like, if it's clear that they don't want to renew to you because of some protected category, like they're discriminating against you based on your disability or your race or gender or whatever, it's just those things are harder to prove. And you may not be able to find representation for that. These are the cases that sometimes the Law Center for Better Housing, if you live in Chicago, can help you with, but there aren't as many suburban legal aid organizations that can provide help with that. And without an attorney, it's pretty difficult. So if you do get that notice of non-renewal, sometimes it's literally just, we're done with this. We just want to sell this building and go, you guys. So but if you have questions about that, when you get that notice, call us at the Cook County Legal Aid for Housing and Debt hotline, and we can at least give you an idea and provide you with legal referrals if that's something that you want to pursue, because there are attorneys who do that work.
Great. In terms of security deposits, if a landlord doesn't return the security deposit, is there a statute of limitations for filing a claim on that? And where do you file that kind of claim?
All right, that's a good question. So, both in Chicago and Cook County, the ordinance dictates that the landlord has to return the security deposit within 45 days. Now, in Cook County, after 30 days, the landlord has to provide you with a invoice if they're intending to withhold money. Okay. Now, what can't the landlord do? The landlord cannot say, oh, I have to take up all the carpet and put in new carpet, and I have to paint all the walls, and I have to replace all the furniture or do whatever. Normal wear and tear is really is basically not like, a couple dings, a couple scrapes. They can't charge you to do a gut rehab, right? So, but again, you also have to give them notification of where you're going. So before you move out, you have to provide them with a forwarding address so they know where to send it. And then if they do intend to withhold some money, they have to tell you within 30 days how much they're going to withhold. And then within 45 days, they have to give you the remainder. Now, if you are challenging because a lot of times landlords be tripping. Like sometimes they'll say crazy, they'll just be like, oh, well, I needed to put in a brand new ensuite bath because of what they did to my apartment. No, no. You're not here to subsidize rehabbing a unit so they can jack up the rent. I mean, if there's some holes in the wall, if you got mad because you were taking the bar exam and you did a bad job and you punched a hole in the drywall, not that that happened to me, it would never. I would never have done such a thing. But let's say that someone did punch a hole in the drywall. Yeah, they could charge you for that. Or if you took a door off the hinges and didn't replace it and they had to get repairs done, sure. But what I don't want you to do is if they send you a partial payment and you don't challenge the rest of it, accepting that money and cashing that check is basically saying, we good, we're cool. So what you can do when after 45 days, if you don't get your security deposit back, or if you get a partial payment back, contact the CCLAD hotline, the Cook County Legal Aid for Housing and Debt, so that we can help you first you would send your demand letter just saying, hey, look, you got to send me the rest of this money. I'm not cashing this check until I get the rest of this money. And if they persist in not paying you the money, at that point, that's when you can pursue legal action. Now, the Law Center for Better Housing in Chicago is a good place to do this. They'll sometimes take up those cases because you can get attorney's fees. You can get 2 times the security deposit plus the original security deposit plus the attorney's fees, meaning you win, they have to pay your lawyer. And there are some private attorneys who will take these cases on contingency. When they win, they'll get paid. You'll get your money reimbursed to you. Now, don't get it twisted. It can take months for this process to work through. But starting by calling us at Carpels is a good way to get the process started because we can help you draft. And even at Daily Center, we have the municipal court advice desk where we can assist with drafting certain documents like this. We won't file it for you or send it for you, but we can help you get the document together that you need that you can send to your landlord to say, pay up, buddy, or I'm going to sue you. And then if they don't pay up, we can provide you with referrals either to a legal aid organization that can help you or to some private attorneys that will take these cases to help you get that money back. Now, as to statute of limitations, I mean, I'm not aware of anybody who's tried to come back 20 years later and get their security deposit. I think most people are broke now and they want the money now. My advice would be do it with the quickness. The minute, like on the 46th day, start trying to get that money.
All right. If a tenant doesn't keep up with their rental insurance and that's a requirement listed in the lease, is that a valid reason for eviction?
It could be. It could be if it's a requirement. Now, I've seen many leases in my time, and sometimes the lease will say, hey, if anything happens in the building, like there's a flood and all of your property is destroyed, we ain't responsible for that. That's a you problem. Some leases do require you to have rental insurance, though. And if you don't have the renter's insurance, that would be one of those situations where they could get you that 10-day notice for a lease violation. And what would the cure be? Go get you that insurance. I haven't seen people, now I've seen people get evicted for a lot of crazy reasons. I haven't in my time as a practicing attorney seen anybody get evicted for failure to have the rental insurance, but it hypothetically it's possible, and a lot more leases are starting to put a provision in there where it's either a requirement or it's highly, highly recommended because, it happens sometimes that, and I'm not saying that I ever lived in an apartment where somebody's bathtub overflowed and like half of their living room crashed into my bill. Yeah, I'm not saying that ever happened to me, but in the event that it did, it would have been helpful if I had had renter's insurance, damn straight, because I had to get a new TV. So
That's an important thing to have.
yeah, but I mean, typically the kinds of things that we see, the 10-day notice where it's a breach is going to be like unsanitary conditions. Are you not taking out your trash? Are you letting your dog like poop in common areas and you're not picking it up? There's various reasons like that that are more typical.
Mhm. All right. We have a question. I've taken the liberty of typing an answer. I'm putting it in the chat right now, but they want to know where tenants should look for official documents and laws on what rights they have and what landlords are required to do. There is, both in Chicago and Evanston, a landlord tenant ordinance. There is a webpage in both cities that is dedicated to that and explaining that. So I threw that in the chat. Want to throw it back to you if there's any place else that people should look
Just do
for.
a cheeky little Google, like you're just always going to just, the letter is always going to be RLTO, Resident Landlord Tenant Ordinance. Just put Evanston. Oak Park has one. Cook County has one. Chicago has one. And just, if it wait, because again, you have to be mindful of the fact, because I've had a lot of people call me on the hotline, just stay away from Chat GPT, guys. Just please. Because I've had too many people call the hotline and say, I've been doing my own research. I'm like, well, I'm sure you have. What did that computer tell you now? Because again, Illinois as a whole has its own landlord tenant law, but when you have a city ordinance, that supersedes it. And the cities sometimes have more stringent rules, right? So you have to look at the Evanston law before you start trying to be like, let's look at the Illinois Forcible Detainer Act. There's a hierarchy, and you're always going to want to start where you live. Evanston has some great protections for its denizens, so take advantage of them and don't trust ChatGPT.
All right. Our next question is whether the 10 days notice can apply to poor housekeeping lease violations for public housing.
Well, typically for public housing, you have to get a 30-day notice. They usually give you more time because obviously there's a reason why you're in public housing. Usually you have limited income, you may be disabled, you may be living in a like you may be elderly or something. So you could still potentially get a 10-day notice. Typically, most like the CHA or the Cook County Housing Authority, they typically will give a 30-day notice. And there's administrative. It's different with subsidized housing because usually there's a bunch of administrative steps and appeals and things you can take. Legal Aid Chicago specializes in subsidized housing cases. So, but if you have a question about what's going on, if there's some issues or violations or something, and there's a lot of public housing is different because they have a lot of regulations and rules. And if you do not follow those rules, you can lose your place. And there's always somebody there, like on a waiting list to take over. So make sure you are following all of those rules, regardless of if you think that they seem somewhat burdensome, because you could lose your place as a result of that. Typically, they'll give you more notice, but you still have to comply.
At what point during an issue like the air conditioning not working should a tenant withhold rent or seek counsel?
Well, I would say the minute that like if if the AC goes off because like the breaker box was overloaded, okay, that's one thing. We're talking about like it depends on the level of seriousness, right? So like if it's like there's no water and then the landlord tells us won't be no water for the near future. Okay, that's we immediately need to serve our notice. We immediately need to seek counsel. What I say is if you have any questions about any of these things, call the hotline. Call us at the Cook County Legal Aid for Housing and Debt hotline. We will be able to hook you up. Call 311. Call those guys immediately because the building inspector will come out. And what these guys don't want to get is those $1,000 a day violations in Chicago. And those building inspectors will hit them with violations, and it's per unit. They could be looking at thousands and thousands of dollars of fees and things. So I say always take action sooner. Don't suffer. Don't suffer in silence. Even if it's only been a minute and you're confused or you're concerned, you want to find out what the next steps are, call us on the hotline, please. Don't
Mhm.
wait. Now if it's just that my toilet is leaking, okay, you don't need to like call out the cavalry for that one. You can probably do some self-help, send your 14-day letter, and if you want help with drafting that letter, call us at the hotline. We'd love to help you.
Great. We have a couple of questions from landlords now.
Sure.
What can a landlord do if he rents to one or two people and then later on more people move in?
Well, that's you could evict everybody at that point. Unfortunately, when and that's why your lease has to be airtight. Okay, so if I were a pro se landlord, meaning I am not an LLC, I'm not like Pangea Properties or one of these big, multinational corporations that have tons and tons of properties everywhere, like run by some private equity group. It's just me and I have this house and I decided to rent it to my nephew, and then the next thing you know he brought in his girlfriend and like their mom or something. You that that would be a violation of an agreement if you made such an agreement. So I say avoid verbal agreements. They're as good as the paper they're not written on. Okay, just don't do it. Even with family members especially, always make sure you have a written agreement. I don't care, like, oh, I will hurt their feelings. Well, you're going to hurt their feelings a lot more when you end up in eviction court, and I've seen people literally evict their children from their homes. You don't want to do that. So talk to an attorney, and you can call us on the hotline. We can help you with the provisions that you need to put in there. But what you need to do is you have to clearly put in your lease, and please don't have ChatGPT write your lease, guys. Don't do it, because it'll take California law in Oregon and crazy, it'll put all kinds of crazy stuff in there that doesn't even make any kind of sense, throwing a whole bunch of Latin that doesn't make any kind of sense. Make sure that you clarify who can and cannot stay. There should be language in there that says only the person who is a signatory to this lease or who is a known occupant. For example, a child, right? So if a mom and a kid move in, they're the people that are allowed to stay. Typically, there'll be some kind of a provision for if somebody is going to stay longer than 10 days, like it's okay to have family come in and visit you, but if they're going to stay longer than a certain period, then you'll need to have written permission from the landlord, or else, you know, any other people staying in here, because you could have fire hazards, occupancy limits. There's all various kinds of building codes that could be violated that could cause the landlord to have fees and fines from the city or the municipality. So make sure that it's clear that if you have these people after this time and I'm not aware of it, that's a breach. We're going to give you a 10-day notice. You better get out. And then they have the 10 days to cure, meaning get those folks out. And if they don't get them out, proceed to eviction.
And those sites that I just put there, the Chicago and the Evanston landlord tenant ordinances, are for the landlords and the tenants. They should have a sample lease that can get you started if you are a landlord. So use that as a jumping off point.
Always have a
Um,
lease, guys. Always have
yeah,
a
always have a
lease.
lease. um, Again, from a landlord perspective, if the apartment is, full of cigarette smoke, can you keep the security deposit over that?
Well, it depends on whether or not you put something in there about no smoking. I think the easiest thing to do would be to put a provision in there's no smoking in the building or any of the common areas. Make it clear where people can and can't smoke. Like, can they smoke on the back porch? And sometimes that's problematic because people will be flicking their cigarette butts into the common areas. So just like this is a no smoking building, and in the event that I think the best way to handle it would be to come up with a discrete number. And what I mean is how much, like, find out from a cleaning company how much it would cost to remove the cigarette smoke if somebody does do that. But probably your best bet would be to just give them the 10-day notice, see if they're compliant, and then evict them before you have a huge issue with smoking. But I think it's going to be difficult to withhold the entire security deposit. you could probably withhold however much it took to do the cleaning, but you're not going to be able to, like, this is why I tell people don't have carpets in your apartments, don't have soft furnishings that are going to suck up that smoke. If it's just smoke on the walls and a slap of paint will help it, you might be able to get away with that, but it's better to just lay out in the lease what they can and can't do, where they can and can't smoke, and what the fee will be for cleaning if they end up violating that.
Great. Can a landlord charge a move-out fee if it's not listed in the lease? There's no security deposit, but there is damage in the unit when someone moves out.
No. Any kind of, I know a lot of landlords are moving away from doing security deposits to doing move-in fees. That's basically what the move-in fee is for, is to cover, like, we're going through, we're doing cleaning, we're maybe repairing and replacing any kind of stuff we're going to replace, and then we're letting the next person move in. If you're it just, again, the same thing goes for landlords as for tenants. If you see, or if you're aware of something happening that is potentially going to damage, act now. Hit them with that 10-day notice. Like, oh, I see you got a dog. Okay, well, you better get rid of it or else you're gone. Or, okay, so you paid your pet fee, your $45 a month pet fee, but this dog is literally chewing holes. And I'm not saying that I personally have a dog that chewed a whole bunch of drywall when they were puppies and then fully destroyed an entire window frame that used to be wood and now is not wood. I'm not saying that happened to me, but it did. But this is my house, so it's my problem. But what you don't want is to let the situation get so bad that the amount of money that it would cost to repair it is going to be unrecoverable. Because remember, your tenants may be what we call collection proof. Okay. If you're in a ritzy place and you got ritzy people, I'm guessing they're probably good for it. But if you're charging $900 a month of rent, those folks are not going to be able to come up with $11,000 to, retool the entire place. So just don't let these things fester, and just be aware that you're not going to be able to hit them with fees when they leave if they did a lot of damage. Or you can maybe take them to small claims court. But again, even if you get a judgment in small claims court, if they're broke, it's like it's as good as the paper it's written on. I mean, you may have the judgment, but if they're broke, you're not getting it. So be more careful in how you select your tenants.
Is there a limit to the move-in or move-out fees and application fees you can charge?
I haven't. I think the limit is what will the market bear. I feel like the typical move-in fee is usually around $500. I haven't seen larger move-in fees than that. I feel like security deposits typically are a couple months, maybe up to a couple months rent, maybe. It's just going to be what the market will bear. If you try to charge somebody a $1,500 move-in fee, I don't know how many people are going to want to move in. Mm-hmm. But you can try it.
What about organizing your neighbors to start a tenants union because the landlord isn't fixing stuff or they want to organize against rent increases? Can landlords stop you from doing that?
Well, the landlords can't. They'll try. If you're in Chicago, the Law Center for Better Housing loves helping tenants organize a union to ensure, because it's better when you have everybody in the building moving together. I'm not saying that I might have like low key unionized the people in my last rental before I decided to go to law school, but I mean that would be retaliation, because if you are just getting people together to make sure that all of your rights under the various Evanston ordinance, Cook County, Chicago, wherever it is, if you're getting together to make the landlord do what they were supposed to have done, and then the landlord's like, everybody out, that's just retaliation, right? So whenever the tenants are doing things that they are lawfully protected doing, if it's a protected act, and you want to get rid of them for that, you're going to be looking at some retaliation. And at that point, they may be entitled to get attorney's fees. And that's where the lawyer's ears perk up like, did I hear attorney's fees? Oh, yes. I'd like $3.50 an hour for that, please.
Yes.
So be mindful of that and just be a good steward of the property, just like the tenants should be good tenants. Let's all get along.
Great. Well, thank you so much, Kimber. This has been great. We will send out to everyone the slides as soon as I get them, as well as the links that I put in the chat here. I'll throw those in also, just so that everybody has everything in one place. So thank you, everybody. We got one more question coming in. Is last month's rent considered security deposit?
No, the security deposit is the tenant's money. That is not your money, landlord. It belongs to the tenant. It should be in the bank. Okay. Now, if you go through the early resolution program, sometimes you can agree to convert that money into rent money. But I know a lot of people are like, oh, I ain't going to pay my last month's rent. They can just take it out of the security deposit. Bye.
Mm-hmm.
No, there's a process, right? So don't do that.
All right. And just for everyone's recollection, what is the name of the law center they should be contacting again?
The Law Center for Better Housing, LCBH. They only cover Chicago, but if you call the Cook County Legal Aid for Housing in Debt, and I'm going to give you that phone number one more time, 855-956-5763, covers all of Cook County. You have questions about consumer debt, mortgage foreclosure, housing of any kind, call us on that hotline. Evanston, Chicago, Schaumburg, call us.
Great. Well, thank you so much. Thank you to everyone participating for coming to this all redhead edition of Law at the Library. We hope that we got your questions answered, and feel free to reach out either to the Chicago Public Library, Evanston Public Library, same place where you registered if you have any questions, and we can help refer you on. Thank you very much, and have a great night, Kimber. Thank you for coming.
Thank you.
All right. Have a great night, everyone. Thank you.